I'm Anita Bryant, and this is my husband, Bob Green. And we'd like to take you to a very special place.
Oh, come along with me to my little corner of the world and dream.
Florida is a fantasy land that conjures images of sunshine and citrus, Disney World and Daytona Beach. It's a place famous for its amusement parks, water ski shows, and spectacular flora and fauna. For many decades, business and political interests have carefully cultivated the image of Florida as a land of progressive ideas, technological advances, and fun. But there's a darker side to the Sunshine State. In his Pulitzer Prize-winning book, Devil in the Grove, author Gilbert King notes that measured per capita, more blacks were lynched in Florida than any other state in the Union, and until recently, Florida was home to a particularly virulent strain of the Ku Klux Klan.
Lord, I can't even walk without you holding my hand. My Lord, I can't even.
And no city more thoroughly epitomizes Florida's well-deserved place in the pantheon of plantation systems than does Groveland. Less than 20 miles from the heart of Disney World, within the figurative, if not the literal, shadow of Cinderella's castle, this small central Florida town is emblematic of Florida's dark place as the deepest of the Deep South. Remarkably, it's a history that's rarely told and is shockingly recent. In 1949, 4 young black men were accused of raping a 17-year-old white girl. FBI files that were eventually produced many decades after the event leave no room for doubt about the innocence of these 4 young men who came to be known as the Groveland Boys. One of the Groveland Boys was hunted down and killed by a sheriff's posse. The youngest, only 16 at the time, received a life sentence. Sheriff Willis McCall took the other 2 Groveland boys onto a remote dirt road where he shot both men at point-blank range. One man died instantly. The other, while having been shot 3 times, survived. The FBI repeatedly investigated McCall. In fact, he was investigated at least 49 times for serious civil rights violations, including murder. Being investigated became such a common event that Sheriff McCall often joked that he'd been accused of everything but taking a bath and called every name but a child of God. In spite of his reputation for violence and racism, McCall served as sheriff of Lake County for 28 years. McCall narrowly lost re-election in 1972 when he was again under investigation, this time for kicking to death a mentally retarded black prisoner. To honor McCall, officials in Lake County named a road after him in 1985. That name, Willis V. McCall Road, remained unchanged until 2007. In 1964, Martin Luther King Jr. was arrested in St. Augustine, Florida, when he and fellow civil rights leaders asked to be served at a local restaurant. In 1970, Governor Claude Kirk ran on a platform that included opposition to desegregation. In 2014, in Polk County, next door to Willis McCall's Lake County, through a series of public records requests, it came to light that Sheriff Grady Judd had directed undercover deputies to infiltrate and spy on African American churches. It was also revealed that the local state attorney's office had attempted to orchestrate with local law enforcement agencies the use of canine units against peaceful black civil rights workers. Florida's southern roots run deep, and it's becoming obvious that some parts of Florida's establishment want to draw the curtains on sunshine and rekindle the embers of Jim Crow. In 2014, Circuit Court Judge Jack Cox issued a final order in the matter of Jeffrey Marcus Gray versus United Group Programs, Inc. The basic facts of the case were not in dispute. Jeffrey Gray visited the offices of United. United has a contract with the Florida Department of Health valued at more than $22 million. The contract calls for United to deliver various cancer screening services to Floridians. The contract also explicitly makes United subject to the Public Records Act. The contract states that United agrees to allow public access to all documents subject to the Public Records Act. It is expressly understood that United's failure to comply with this provision shall constitute an immediate breach of contract. In addition to the clearly stated provisions of the contract, the court's analysis also concluded that United is subject to Florida's exceedingly broad Public Records Act. The court wrote, in evaluating the totality of the factors, the defendant is performing a function of the Department of Health and qualifies as an agency subject to the government in the Sunshine Act. The court found that during normal business hours, Gray visited the address listed in the contract as the location where public records are required to be stored, that Gray asked to speak with the person listed in the contract as the individual responsible for the administration of the contract, that Gray clearly articulated his public records request, and that the defendant clearly understood it. The court further found that the requested record did exist and is subject to disclosure under the terms of the contract and the Public Records Act. Here, however, the court's final order takes a bizarre turn to become one of the most ominous decisions in recent memory. The court held that because Gray was wearing shorts, flip-flops, and a t-shirt, the defendant was reasonably uncomfortable with Gray and therefore had no obligation to respect his constitutionally protected civil rights. In other words, a public official is not obligated to respect the civil rights of any person whose appearance makes him or her uncomfortable. While it's true that Jeff Gray is white, it does not take much imagination to see how such a decision will be used as license to discriminate against anyone whose appearance a public official finds off-putting. And given Florida's tragic and recent history of racism, one can only imagine how Judge Cox's decision will be received in some parts of Florida. Although some folks, including members of Florida's business and political establishment, may brush off such concerns as hyperbole, folks who have experienced discrimination firsthand do not.
So, how does it make you feel to learn that a circuit court judge in Florida has decided in a final order that it's okay for public officials to take into consideration what a citizen looks like before they decide whether or not they're going to respect their civil rights?
I think it's the rebuilding of the old South under the system where segregation and racism was accepted. If they're being permitted to respond like this now with all of the legalities that are in place to protect my civil rights, if something like this happens, I mean, it's just it's free course to do whatever you want to. Public records is a very powerful tool, and being able to access those records gives us light into what people are doing, what people are saying, how people are responding, and how people really feel. And eliminating that for those who do not look a certain way or does not meet a certain criteria leaves it up to an individual to decide who's going to get the record. And that's a problem.
What is becoming increasingly clear is that certain factions within Florida's business and political establishment are so determined to operate in the shadows, they will do almost anything to keep the public out of their business, even if that means resurrecting Jim Crow.
Nobody knows the truth.